Attorney General.
Thank you, Mr. President. I beg to move that a bill entitled An Act to Amend the Administration of Justice, Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. And may I put at the masthead of everything that I will say today, Mr. President, the fact that we are today considering legislation to abolish preliminary inquiries, which concerns the pre-trial stage of the criminal trial process. We must not lose sight of that in the context of all that will be said and the significant moment that we now are at in this august chamber. Mr. President, the bill before the Parliament is a significant tool in reducing the endemic delay in the criminal trial process. The statistics demonstrate that as of March 2023, there are approximately 37,933 pending indictable matters at the district courts. This means that there are 37,933 criminal offenses, serious criminal offenses, including murders, attempted murders, robberies, rapes, trafficking in persons, misbehavior in public office, and other types of fraud, which are currently pending at the pre-trial stage. A pre-trial stage, Mr. President, which in the norm in Trinidad and Tobago over the past several years, going into more than a decade, ordinarily takes 2 to 3 years, on certain occasions, including matters which are still current, as much as 15 years. These numbers, Mr. President, do not merely represent pending matters or charges. They represent thousands of persons whose lives have been disrupted, who wait in abeyance on some form of progress and or closure to serious criminal matters and charges which have followed them like a shadow for many years. Every one of those 37,933 matters, Mr. President, involves an accused person or multiple accused persons, a victim, sometimes multiple victims, tens of witnesses, interested family members, and of course the affected public. This is the reality of our criminal justice pre-trial system. To add to this staggering number, Mr. President, is the average of 8,835 indictable matters filed annually, which now join the queue of the 37,933 pending matters. Critically, we accept that the work of conducting preliminary inquiries is shared between the Office of the Director of Public Prosecutions and the Trinidad and Tobago Police Service. At current, the Office of the DPP has under its conduct approximately 2,120 preliminary inquiries. For the period 2013 to 2023, the office has concluded 900 preliminary inquiries. We have requested statistics from the Trinidad and Tobago Police Service, and the data from the Court and Process Branch of the Trinidad and Tobago Police Service reflects that there are currently 1,326 preliminary inquiries under the purview of that branch. In looking at those statistics, Mr. President, with an overall average of 37,933 pending matters and an additional approximate 8,835 matters joining the list every year, it is clear that the pre-trial stage of our criminal justice system is in dire need of complete overhaul. This is an undisputed fact and cannot be allowed to continue. There can be no dithering. In my respectful submission, there can be no interference in the discussion and the decision-making process which we are going to engage in by introducing personal or political differences. We have to put those aside because the people of this country demand better, demand decision, and demand action on our part. Mr. President, from the outset, may I say, from as early as 2015, the government has prioritized the abolition of preliminary inquiries as a significant step in the improvement of the criminal justice system. In 2022, we made a final call, including previous calls, to stakeholders and received feedback from the Office of the Director of Public Prosecutions, the Judiciary, the Public Defender's Department, the Trinidad and Tobago Police Service, and engaged in substantial consultation processes. From the Law Association of Trinidad and Tobago, from the Criminal Bar Association, and from 2021, Mr. President, the reconstituted Criminal Justice Committee, chaired by the Honourable Chief Justice, has continued and engaged that process of consultation. That committee is composed of, among other heads of departments, the Attorney General, the Chief Magistrate, the President of the Law Association, the Commissioners of Police and Prisons, the Chief Public Defender, and the Director of Public Prosecutions. The time has come, enriched by that process of consultation and significant hard work, Mr. President, for us to engage today to pass the bill which is before this House and to abolish the lethargic and indolent system of preliminary inquiries and move to a fast-track trial process. The current pretrial system, Mr. President, is governed by the Indictable Offences Preliminary Inquiry Act, Chapter 1201. In 2005, we saw the introduction of paper committals, which was an attempt then to improve the system. The harsh realities, those paper committals have led to the use of written statements and documentary evidence and the use, and one might even say the abuse of multiple cross-examination, multiple pre-trial processes that have allowed for inordinate delay in the disposition of preliminary inquiries, with 88% of preliminary inquiries into capital matters taking over 2 years to completion. It has led to an undue incarceration of accused persons who are eventually found, many of whom are eventually found not to have had a prima facie case made out against them after close to a decade of imprisonment. It has led to the obvious depletion in the quality of evidence, both at the preliminary and subsequent trial stages, to the failing memory of eyewitnesses, and to the increase in the number of witnesses who have died or cannot be located to provide testimony and subject themselves to cross-examination, which cross-examination is sometimes prolix and conducive of even further delay. We begin our conversation on this piece of legislation before this House today, Mr. President, by reminding ourselves that we have the ruling of our highest court that it is not in any way unconstitutional to abolish preliminary inquiries. The case in point out of Antigua is Hilroy Humphreys and the Attorney General of Antigua and Barbuda, 2008 UK PC, in which the Privy Council held that the defendants in criminal proceedings do not have a vested right to any particular procedure, and there will generally be nothing unfair in applying whatever procedure is in force when the case comes to court. Section 53 of our Constitution, Mr. President, charges us with the responsibility to make laws for the peace, order, and good government of Trinidad and Tobago. And that is what we are here about today. Mr. President, the bill before us, if I may speak with some measure of emphasis, involves us taking a hard look at our systems and introducing a new system which is going to be allowing defendants, accused persons, the right to a fair trial, allowing a fulsome role for the Office of the Director of Public Prosecutions, the independent office charged with the conduct of prosecutions under our system, and is going to divide the trial, the pre-trial process, substantively into two compartments, the initial hearing and the sufficiency hearing. I will come to that. But may I, in anticipation of comments which I have no doubt will be made, may I say, Mr. President, that in the process of coming to this House with this bill, among other persons who have been consulted on this piece of legislation, I have listed them all, but I would emphasize the Office of the Director of Public Prosecutions has been consulted. Several letters have been written to him inviting his input, and he has made input. And may I say, Mr. President, with reference to the Office of Director of Public Prosecutions, that I continue to engage with that office, an important part of the criminal justice system, in order to ensure that we make progress in improving our criminal justice system. I have personally participated in meetings with the Director of Public Prosecutions and the Chairperson of the Judicial and Legal Service Commission as recently as April 2023 to address some of the challenges. I'm informed that interviews for State Counsel were conducted as recently as early May 2023, and of course, I give the assurance to the public, the citizenry of this country, that the Office of the Attorney General continues to place the Office of the Director of Public Prosecutions, the independent office, at a most pivotal stage in the improvement of our criminal justice system. Mr. President, I would move to the clauses of the bill. I will emphasize some at the outset. Clause 4 of the bill before us, among other things, which deals with definitions, introduces the concept of electronic filing, which reduces our archaic paper-based systems. Clause 15 introduces the early filing of the indictment, that most important document which commences, really, the process of the criminal trial, and which has been for far too long delayed at the latter end of the process. We are now bringing it in to the first stage of the criminal trial process. And clause 15 will deal with the scheduling order. I will come to that, and we will get to the sufficiency hearing. What we are seeking to do by this bill is to reduce the extent to which the pre-trial stage of a criminal trial becomes mired in a lengthy and unduly delayed process, as if it were the trial itself, when it is not, because all that the pre-trial stage is intended to do is to satisfy, under the system that exists now, the magistrate, and under the system that we are going to introduce under this bill that is before this House, the master, that a sufficient prima facie case has been made out, at which stage the case is transferred to the High Court judge so that the actual criminal trial can get moving. And if we do what we are going to accomplish under the bill that is before this House, we will move, Mr. President, and I emphasize this, we will move a sea change in our criminal trial process, because we will move from a process by which persons are incarcerated during the pretrial phase for up to 3 years, sometimes as much as 10 years, to a period of hopefully not more than 6 months, at which stage, if a prima facie case has been made out, the case goes to trial and is dealt with at the trial stage. Mr. President, the bill before this House is long, 45 clauses long, and I am hoping not to spend an undue period of time going through the clauses clause by clause, but rather to highlight the relevant clauses, the more important clauses. So an example of the highlight is clause 2 of the bill, which provides for a proclamation clause. And that proclamation clause is important because what it means is that after, and I say this with confidence and optimism, after we pass this bill this evening into law, a period of time will be permitted before proclamation so as to enable further consultation, training, and sensitization, so that when the bill is finally proclaimed, all shoulders are to the wheel of an improved criminal justice machinery. We have a definition section, Mr. President, Clause 4. And Clause 4 of that definition section deals with a number of different definitions. The term appropriate adult is one of the terms used in the definition section, which simply means, with reference to Section 3 of the Children's Act, that appropriate adults who are listed in Section 3 will be available to accompany the children who come before the courts under different offenses before the different children's courts. It also includes, Clause 4, an expansion of the prosecutor, because what this bill seeks to do through Clause 4, as it introduces the concept of police prosecutor, is to encourage, by an amendment to Section 64A of the Police Service Act, to encourage police prosecutors to comply with the requirements of the Legal Profession Act, so that fully legally qualified police officers can function as prosecutors to assist and support the Office of the Director of Public Prosecutions in prosecuting cases at the indictable stage, at the initial hearing, at the sufficiency stage. Mr. President, Clause 5 of the bill before us seeks to amend Section 4 of the Preliminary Inquiries Bill. And among other things, it empowers magistrates to determine those cases in certain circumstances which are to be determined in accordance with the new act when we pass it, or whether they will remain before the magistrate at the stage before this act came into force. Mr. President, Clause 6 seeks to amend Section 5 of the act. And that Clause 5, Section 5, was further amended in the House of Representatives before we came here today. And may I just emphasize that the purpose of that amendment, which I brought before the House of Representatives, was to ensure that premises which are referred to in Section 5, when they are to be searched or seized, have the protection of due process and the protection of law if ultimately the magistrate, the master, under this new legislation, were to authorize the search of premises which are not named in the search warrant, but have to be satisfied. The master has to be satisfied that the provisions of Section 1 of Section 5 are satisfied. And that was the purpose of the amendment which we brought in the House of Representatives. There were other amendments that were made to Section 5, which is identified at Clause 6, and we will address those in due course, Mr. President. We also make provision, Mr. President, for the initial hearing stage of the preliminary trial stage. And the initial hearing stage, Mr. President, is a very important stage, and I have asked for members of this Senate to be provided with the consolidated version of the legislation which is being amended. And the initial hearing stage of the trial is introduced at Section 11 of the Act, and that is a section which is being amended in significant terms. So if members would stay with me as I look at Section 11, which is being amended under clauses 15 through to 19 of the bill before this House. That initial hearing stage brings significant features to the improvement, Mr. President, of the trial, the pre-trial process. Significantly, what is introduced by the amendment to Section 2, Roman H3, is that the prosecutor, and I am now at Section 2, H, Roman 3 of the consolidated, the unofficial consolidated bill, the prosecutor shall file in the High Court and serve on the accused the indictment and all witness statements and other documentary evidence that he intends to use at the sufficiency hearing, which date shall be no later than 3 months from the making of the schedule in order or such longer period as the master thinks fit. The significance there is that the indictment is being introduced at the very beginning of the process. We have cases before our courts right now, Mr. President, in which persons are on remand yard for 3 years and the indictment has not yet been served. It is mandatory from the minute this case comes before the master, when you look at the amendment that is being proposed, that the indictment shall be served by the prosecutor on the accused, all witness statements, and I've already addressed that, and that he intends to use it at the sufficiency hearing. The sufficiency hearing date shall be no later than 3 months from the date of the making of the schedule in order, which the master is managing at this very early stage. Roman 4. The accused shall file in the High Court and serve on the prosecutor any witness statements and other documentary evidence that he intends to use at the sufficiency hearing, which date shall be no later than 28 days. So again, strict timelines are being introduced. Roman 5. The sufficiency hearing shall commence, and we will get to the sufficiency hearing when we come to sections 19 through to 37 of the consolidated version. The sufficiency hearing shall commence, which date shall be no later than 28 days or such longer period as the master thinks fit from the date specified under subparagraph 4. So we see that with the introduction of the amendment that is brought by Clause 15, that the indictment is filed immediately, we immediately introduce a timeline under robust court management by the master to ensure that the trial is taken forward in an expedited manner. I cannot stress too much, Mr. President, the importance of the filing of this indictment at the initial hearing stage in ensuring that the pretrial proceedings are conducted with greater efficiency. And significantly, Mr. President, this does not interfere with the Director of Public Prosecution's ability to amend, add, or withdraw counts on the indictment as needed. So, Mr. President, that is, in my respectful submission, one of the most significant introductions, one of the most significant amendments that is being made by the clauses 15 through to 19 of the 11 through to 19 of the unofficial consolidated act, which is introduced from clause 15 of the bill before this House. And then we get, Mr. President, to clauses 20 through to 27. Clauses 20 through to 27 then introduces the sufficiency hearing. And at this stage, what we have before the master at the sufficiency hearing stage is the indictment and all of the witness statements and other documentary evidence which has been filed by the prosecutor and the defense, the accused persons, assisted by legal aid. All of that is prescribed in the earlier sections of the unofficial consolidation. And at this stage, the master will address the sufficiency hearing on the paper before her or him without engaging in the protracted preliminary inquiry process which currently bedevils our criminal justice system of lengthy cross-examination, prolix cross-examination, a multiplicity of witness statements that are introduced over time. Clauses 20 to 37 of the bill provide for the sufficiency hearing. Mr. President, Clause 20 of the bill will amend Section 19, and the Clause 19 will improve the language by deleting and substituting certain chapeaux in order to improve the language and ensure that the procedure is properly explained. The clause will also repeal subsections 6, 7, and 8 and substitute new subsections 6, 7, and 7A in order to adequately deal with adjournments at a sufficiency hearing. Another ill that bedevils our criminal justice system. Undue adjournments that are allowed in the absence of a robust judicial management. One of the things that this bill is introducing is a very robust judicial management process. Clause 21 of the bill will insert after Section 19, Mr. President, a new Section 19A dealing with witnesses and witness statements as it pertains to the sufficiency hearing. It is proposed that the attendance of a witness shall not be required at a sufficiency hearing unless, on application, the master makes an order for the attendance of a witness who filed an unsworn statement. This, Mr. President, is a pivotal change to the way pretrial procedures are conducted. The addition of oral evidence by way of further evidence and cross-examination has been identified as a major cause for the protraction of the current preliminary inquiry process. Clause 23 of the bill, Mr. President, will amend Section 21 of the Act by deleting subsection 2 and paragraph C and D and inserting new paragraph C and D to ensure that there is clarity in procedure as it relates to the admissibility of prosecution witness statements. This clause will also amend sections 21.3 and 21.3a by deleting the words adult of choice and substituting the words appropriate adult, and I've already addressed that with reference to clause 4 and the definition of appropriate adult which one finds in section 3 of the Children Act, and deleting the words or any other person qualified, substituting the words child psychologist, social worker, counselor, or other person who is similarly qualified, respectively. Clause 23 of the bill, Mr. President, will delete DA in relation to section 21.4a and substitute a new DA in order to clarify the procedure as it relates to a statement by a person who does not speak fluent English. Additionally, this clause will amend section 21.5 by repealing it and amend section 21.8 by repealing and substituting a new section 21.8 which pertains to a transcript of proceedings and evidence obtained under a treaty to be admissible as evidence at a sufficiency hearing. Clause 24 of the bill will amend section 23 of the Act by deleting paragraph B and substituting a new paragraph B to clarify the procedure and to provide for the Criminal Procedure Act relating to orders under Section 25 concerning a master's final decision at a sufficiency hearing. Clause 25 of the bill, Mr. President, will amend Section 24 of the Act by inserting in subsection 1 the words on the indictment which concerns the discharge of the accused. This clause will repeal subsections 4 to 11 of Section 24 of the Act and substitutes it with new subsections 4 to 6 in order to allow the Director of Public Prosecutions to appeal the decision of the master if the director is of the opinion that the accused ought not to have been discharged. It also allows for the appeal of a master's decision to the Court of Appeal in accordance with Section 65C of the Supreme Court of Judicature Act. I pause there just to emphasize this point, Mr. President, because in the other place, much was said about the fact that the jurisdiction of the independent director under Section 90 of the Constitution was being eroded to the extent that the master was being given the power to second-guess the decision of the Director of Public Prosecutions. And what this section does is to allow the Director of Public Prosecutions to appeal to the Court of Appeal in accordance with Section 65C of the Supreme Court of Judicature Act if the master has made a decision with respect to the sufficiency hearing that the decision that the director is not happy with. So there is no erosion of the function of the director, because to the extent that he is allowed to appeal the decision to the Court of Appeal will be able to review the decision of the master, and if the director makes out a successful appeal, will restore the decision of the director. Clause 26 of the bill, Mr. President, will amend Section 25 of the Act by repealing subsection 1, substituting new subsections to deal with an offense under the Criminal Procedure Act. It allows for the indictment to be amended accordingly. The clause also amends Section 25 by repealing subsections 2 and 3, deleting and substituting words in subsections 4 and 5 to ensure clarity of language as it pertains to the Criminal Procedure Act. Clause 27 of the bill will amend Section 26 of the Act to clarify the language relating to the procedure of transmission and custody of documents and exhibits relating to a case. Mr. President, clauses 28, 29, and 30 of the bill will amend Section 26A of the Act by repealing Section 26A, which has now become obsolete, would amend Section 26B of the Act by repealing Section 26B and amend Section 26C of the Act by repealing the current Section 26C. Section 26C allowed for the DPP to determine which case is to be dealt with summarily or indictably after the completion of an entire sufficiency hearing. And this, in our respectful view, defeats the purpose of this fast trial law. While this has been repealed, the idea is that the DPP has early notification of whether or not a matter will be dealt with summarily or indictably, and does not have to wait until after an entire sufficiency hearing is completed to exercise that power. In our respectful view, this is a waste of judicial, prosecutorial, and other resources. Clause 31 of the bill, Mr. President, will amend Section 27 of the Act by repealing Section 27. This effectively removes Schedule 6 matters which were exempted from discharge. This is better aligned now, as the indictment is now being filed at the beginning of the sufficiency hearing process, so there's no longer a need to have a schedule which exempts matters from discharge due to delayed filing of the indictment. Clause 32 of the bill will amend Section 28 of the Act by deleting paragraph C of Section 28(1), inserting a new subsection 1A to account for where a master has referred an accused to a judge for sentencing following an early guilty plea, and the Director of Public Prosecutions must be given notice of that referral. Clause 32 of the bill amends Section 28 by repealing subsection 2, substituting a new subsection to allow for when a master refers an accused to a judge for sentencing, for the statement of the accused to be reviewed in evidence upon its mere production without further proof. Clause 36 of the bill will amend Section 29(2)(b) by allowing the oath of a credible witness whose attendance is not reasonably practicable as a result of being outside of Trinidad and Tobago, and for that person to be secured, that person's evidence to be secured either physically or by electronic means. This clause will also amend Section 29 of the Act by repealing Section 29(7). Clause 37 of the bill will amend Section 30 of the Act by repealing subsections 1 through 6, substituting subsection 6 with a new subsection to account for an indictable offense being dealt with by the High Court in accordance with the Criminal Procedure Act. And I emphasize the point throughout, Mr. President, that the Criminal Procedure Act, an involved, detailed piece of legislation, remains in place as the legislation which regulates the trial at the assizes, where the real trial takes place after the preliminary pretrial stage has been expedited by the amendments that we bring by reason of this bill. Clause 38 of the bill, Mr. President, will amend Section 32A of the Act by deleting and substituting words to clarify the procedure, deleting subsection 5, substituting a new subsection 5 to state that when notice is given to the registrar under subsection 3, the registrar shall issue a notice to the accused to appear before a master on the date specified in the notice. Clause 39 of the bill will amend the Act by inserting a new Section 32, new Section 32B to deal with anonymization of documents for a variety of reasons. For example, the protection of witnesses. Importantly here, the original version of the document is always retained for court and internal purposes. And again, in the other place, Mr. President, a lot of time was spent criticizing the anonymization process on the mistaken assumption that this had to do with anonymizing of witnesses. This is not the anonymizing of witnesses. It is the anonymization of documents. The witnesses, their witness statements have been served, but they are vulnerable persons, and it's all spelled out in the legislation. Persons who have to be protected, and therefore there is a process of anonymization of documents in order to give some comfort to persons who are identified in what can sometimes be a very harsh spotlight of the criminal justice system. Clause 40 of the bill will amend the Act by amending Section 33(2), deleting the words, neither the prosecutor nor the accused elects to have the case determined in accordance with this Act, and substituting the words, no order is made under Section 32A, in order to allow for savings under the Indictable Offences Preliminary Inquiry Act. Clause 41 through 44 of the bill will amend Sections 34 throughout. Clause 42 of the bill will amend Schedule 5 by deleting Form 1 and substituting a new form. Clause 43 of the bill will repeal Schedule 6. Clause 44 of the bill will amend Schedule 7 to the Act by repealing Schedule 7 and substituting a new Schedule 7. And finally, Mr. Speaker, Mr. President, Clause 45 of the bill deals with consequential amendments as a result of the passage of this legislation. The Summary Courts Act, the Criminal Procedure Act, the Criminal Procedure Change of Venue Rules, the Police Service Act, and the Family and Children Division Act. Mr. President, this bill, when we pass it today, will complement a host of reforms which this government has already brought to the Parliament and has brought to this country. And I can identify a few. The backlog identification at all levels of the court and prosecutorial division, the creation of divisions of court, the introduction of judge-alone trials, the decriminalization of road traffic offenses, the introduction of new plea bargaining legislation, the increase in judicial capacity and support systems, the creation of a public defender system, the enhancement of the prosecutorial system, the introduction of criminal procedure rules, the implementation of a fully computerized case management structure. Mr. President, when we look at the benefits to be gained by the passage of this act, I could give an example in terms of timeline. The new trial procedure from charge to discharge or committal for trial is approximately 6 months, as opposed to 2 to 3 years, or in some cases, as much as 15 years. Search warrant, the constable is to complete and file the report in the High Court within 14 days. The accused appears and is brought before a master for an initial hearing. At the initial hearing, the prosecutor is to file and serve on the accused the indictment no later than 3 months. The master, of course, has a discretion. At the initial hearing, the accused must file and serve evidence on the prosecutor no later than 28 days after the prosecutor has filed and served the indictment, of course, with the master having a discretion. In the case of adjournments, the adjournment shall be for no longer than 28 days unless with the consent of the parties. The accused must serve notice of his alibi within 28 days from the initial hearing. The sufficiency hearing must commence no later than 28 days after the accused files and serves evidence, of course with the master preserving a discretion to manage the fairness of the process. And at the sufficiency hearing where an accused is remanded to stand trial, an adjournment shall not be for more than 28 clear days.
Attorney General, you have 5 more minutes.
Thank you very much, Mr. President. At the sufficiency hearing, the accused can be discharged by the master on the written request of the DPP and must transmit within 14 days the record of the sufficiency hearing. Again, if at the sufficiency hearing the accused admits guilt, he must appear before a judge for sentencing within 3 months. The trial witness statements must be tendered 21 days before trial. At trial, the DPP shall, at least 28 days before the date fixed for trial, give notice to the registrar of the information on witnesses whom he desires to attend at the trial of an accused at the High Court. And that is the stage at which one then introduces the fairness of the process involving cross-examination of witnesses and the like. Mr. President, the reality is that we really simply do not have a choice. If we are to progress our criminal justice system, we have to move out of the lethargic and indolent system which has been characterized by the preliminary inquiry stage, which I said at the beginning and I repeat now as the masthead of my submissions, is no more than the pre-trial stage. What we are seeking to do is to shorten the pre-trial stage to give an accused person his entitlement to a fair hearing at the assizes if he's committed, and if he's not committed because a prima facie case has not been made out, then within 6 months from when he was charged and brought before the master, he can walk free and get on with his life. Mr. President, with leave of this court, this House, I beg to move.
Honourable Senators, I shall now